Thank you all for joining us at Folks' the 92nd Street Y and for Law of the Land, which is sold out. It's always sold out. It is ridiculously a fan favorite. We started, this is like the 9th consecutive year, and it just shows you people have an enormous interest in the Supreme Court. They have no idea what goes on. Phenomenal interest. They would love to be able to cocktail party and be able to say something, but they go, yeah, that's Supreme Court. Yeah, they're really conservative. But we actually tell you what you can say. You know, we always say at a Folks event, everyone leaves smarter and laughing, entertained, and you'll have something to say at a cocktail party about all the cases that are of general public interest. Before we start, let me say a few words about our friends here. Many of the people on our stage have been returning guests. So for instance, Mark Stern has been here before. He is truly a fan favorite. There is a liability with having Mark, though, a serious problem, and I think I'll just say it. You can't mention Clarence Thomas here, and which it makes it very hard to do. He just starts, once he strangled me. So he's just very sensitive, and so, you know, he goes nuts. So that's Mark. If you see, you'll see how I try to avoid mentioning that guy. Jess Bravin from the Wall Street Journal is new to us. This is his first year. He came to us from our farm system in Des Moines, Iowa. We have a lot of land there. It works too. Farmers like it. But Jess knows that this is like a hazing ritual, and he wants to come back. So, you know, be really supportive. The lovely Tiffany Graham is a colleague of mine at Touro. She's a dean and a constitutional law professor. And there's also something very interesting about her that you may remember a number of years ago. She surprised us all by telling us that she goes all Taylor Swift fangirl when Ketanji Brown Jackson was, and that was the sweetest thing, because no one thinks that law professors are human and lovely like that. Like that the story was that it was your Harvard reunion, and you couldn't make it, and Ketanji Brown Jackson had just been appointed, and we were discussing it, and the first thing that Tiffany wanted to say is, and I missed my reunion. She had an opportunity to go all fangirl, so that's very sweet, and that was a good, thanks for showing that side of you, Tiffany. And my old buddy, Bill Traynor, the dean at Georgetown Law School, he's the longest serving dean in the United States. He is the Cal Ripken of law school deans. He is also a co-founder of Folks. So if you think this is interesting and you've been following us for years, I was reminded, he was at that time the dean at Fordham when I was at Fordham. Our very first event, and I just told him the date, was January 20th, 2006. And it was an event, you know, we do all sorts of things at folks.org, different kinds of events, film series. We did an event with Tony Kushner, as you know, wrote Angels in America, and E.L. Doctorow, the novelist who wrote the Book of Daniel. And we did a night devoted to why the Rosenbergs, Ethel and Julius, influence artists. Why can't we get that out of our creative imagination? And so we had two masters, a dramatist and a novelist, and it made the front page of the New York Times art section the next day. That's how Folks started, and this guy's responsible for that. There's also something else to say about Bill. You know, yeah, he went to Yale Law School, that thing. He also has a PhD in legal history from Harvard. That's important, because when we talk tonight, you'll know in the last several years, the Supreme Court is talking a lot about how to interpret cases in terms of legal history and American history. So to have someone with that perspective is very important. Now, at some point, Bill will probably turn to me, and you'll see, and he'll say, so I'm just curious, how many PhDs do you have? And I will say, none, Bill. And he'll say, it's interesting to know. And you would think he'd remember, but he'll ask that question. Bill, you're way smarter than I am. We know that. You're smarter than a lot of people, but you're way smarter than me. All right, let's start. Before we do start, if you are at home, it's not too late for CLE credit, even though I think most of you here are civilians, which we love. But if you're online, you can still sign on here and online. And in order to start the clock, your number is FLC, Frank Lovely Cat, 987, FLC 987. At the end of the night, I'll give you your closing thing, and then you can keep your license. Okay, so what we normally do is before we get into the cases, we talk about sort of interesting things that have happened. Sometimes we like scare the shit out of you. You know, like we say, like Bill said 3 years ago when, I don't know if you remember this, scared the crap out of the audience. He said, you know, well, now that Amy Coney Barrett has joined the court, I can tell you right now that Roe v. Wade will be overturned next year. And I looked at him like, what are you, nuts? Like, you're not going to overturn. And sure enough, 9 months later, they overturned Roe v. Wade. And that was an example of scaring the crap out of you. And also a sign of an incredible call, because I thought that was, I don't think anyone else here believed that. But yeah, 9 months later. But there are some things this year that are interesting. We don't have a new justice, but a few things I just want to cover, see if you have any thoughts. One is, it seems like the Supreme Court is hearing fewer cases and deciding longer, taking longer to release them. So much so that this year they went past the deadline. They went to July 1st. They normally finish before the end of June. So it's important to remember in the 1970s, 1980s, court would hear 200 cases, 150 cases. This year they heard 62. So they heard 62, and they took longer to reveal them. Also, I say this every few years just to remind the audience. You do know when your next door neighbor threatens you with some lawsuit and says, I'm taking you all the way to the Supreme Court, you should always say, I don't think you will. I don't think that's going to happen. The reason is the Supreme Court receives petitions every year from 8,000 to 10,000 cases, and they only decide to hear a small number. So if there were 8,000 or 9,000 petitions this year and they only decided 62, your odds are very low. So don't let anyone threaten you with that. It's very unlikely, low odds. Why, do we have any sense about, should we dock their pay? Like, why are they doing less work? Don't we want them to take more cases? Don't we want them to deliver them not at the end so we can't even process them? Anyone, any thoughts?
Well, so the Supreme Court is deciding fewer overall cases, but they're deciding more major cases every term. And I think we're all still recovering from the last few weeks where it was just flooding the zone with blockbusters every day. And that is actually the result of a series of reforms that most people didn't notice that ended in about the 1980s, which was Congress giving the Supreme Court total control over its own docket. For most of American history, Congress told the Supreme Court, you've got to hear these cases. It was called mandatory jurisdiction. And a series of chief justices made the very persuasive case to Congress that they were too lazy to decide all those cases, and that it was really interfering with their work-life balance, and that Congress should give them near absolute control over the cases they could hear so that they could hear fewer. And Congress acquiesced, as Congress throughout history has so often acquiesced to the Supreme Court's requests. And so what we see now is that the justices have, again, near total discretion over which cases they'll hear. That means they're able to shape their agenda in a way that I think very few of us perceive. They are able to reach into that bucket of 8,000 appeals and pluck out the handful that give them the opportunity to get where they want to go, to check items off their agenda. And I think that's why we're seeing this strange phenomenon where it's only about 60 decisions instead of 150 to 200, but a third of those are massively important decisions that wreak havoc and major change in the law because the justices are, again, essentially manipulating their docket like a politician might, frankly, in order to enact an agenda that doesn't look very judicial and looks very much legislative.
And what Mark said is true about this flooding the zone. It's more than just flooding the zone. This year, and I know some of you, I don't know if anyone has been here 9 consecutive years, but this is a very rich year. This is a great year if you're following the Supreme Court. Why? Because normally, I got to tell you, when I'm preparing for this, you know, some of the cases are really hard to explain. You know, they don't have kitchen table appeal. You know, subsection C of some statute, and you know, is this interpreted this way or that way? So many of the cases that showed up in the last 2 weeks, everyone can understand. It's something that, you know, can a person who has an order of protection against them for spousal or domestic violence, can they own a gun, right? I mean, if a state doesn't allow abortion, like a restrictive abortion, but a hospital takes Medicare, and the hospital knows that under Medicare, you have to treat the patient if they come in the emergency room, can you get an abortion if you go to the emergency room? That's, wow, cool. Like somebody thought of that, right? The people in Idaho were going, wait, how you can't do that? We say you can't do that here. Well, maybe if you go to the emergency room. So we're going to talk about some of those cases. So they're not just blockbusters, but they're also something I think that are accessible. They're interesting.
But I think, there are two things that I think are going on. One is the Supreme Court has been changing the law in areas that are of profound impact, right? So they overturned Roe. So then the question after Dobbs, which is the case that overturned Roe, is, well, what kind of abortion regulations, can a state do?
Right.
Or 2 years ago, they overturned the law on gun control. So now they're grappling with, well, what does that mean? What kind of regulations?
And those two cases I just said
so those are cases
examples.
The law changed, and that's one of the reasons why we now have blockbusters, because the law is now uncertain in a way that it hasn't been before.
And I would add to that also, I know that we often don't want to think about the members of the Supreme Court as being overtly political, or maybe you do, I don't know. But what I will say is, given the fact that we now have a 6-3 conservative majority, and it only takes 4 votes to grant cert in a case, it's quite possible that in the past, when it came to these controversial, very ideological questions, it may not have been clear whether or not there were enough votes to get the outcome that one would have desired, because if you only had 5 conservatives and 4 liberals, it wasn't always clear how it would end up. But now that you've got 6 conservatives on the court, it's probably a little bit easier to game out whether or not in these big cases you can get the result that you actually want.
All right, 2 more preliminary things we'll get to cases. One is wives. I'm interested, wives were important this year. Alito's wife got in an argument with their next door neighbor. She hates his guts. And she started flying, I guess it was January 6th insurrection flag, upside down. I don't know what she was doing, but she knew how to get to him. And the court, as you know, this year heard, we'll talk about, what it could be described as clearly a January 6th case. And if you're flying a flag that seems to be supporting the January 6th rioters outside your house, how could you possibly be deciding impartially this case? Similarly, we know that Clarence Thomas's wife, is he sitting? It's just still there, okay. Clarence Thomas's wife, it sounds like she was really involved with the White House in talking about what to do about the election. She spoke to the chief of staff. Like, what are we doing about this election? There's got to be a way to overturn the results. So those questions came up, and one of the things that I think was sort of a curveball was when Alito said, I don't tell my wife what to do. The guy pissed her off.
Have you met her?
She's ferocious.
She's a strong-willed person.
Just
I would say she's a strong-willed person.
So you're saying you believe that it's possible what he's saying is absolutely true. I don't control my wife.
Yeah, I think it is. I think it is. I don't think he. He said that he's not a fan of flying flags. She is. I mean, what would you say? I mean, this is the idea that he would want to fly the flag and would then concoct a story of hiding behind his wife's skirts does not make any sense, because one of the photos that ran, I think that he may well have been behind one of the flags. It was the Phillies flag, which was also on their flagpole, and we know that. I mean, he went to Phillies camp, so that suggests he has some role in the flagpole policy. But
You're saying he has access to the flagpole.
He may certain hours.
All right. So before we get to the cases themselves, one thing that seems to be common, and I think most members of the audience don't understand this, which was the cases, many of them were decided without decided. You hear this all the time. The court decided this on the basis of standing. Procedurally, they use the term of art. They never got to the merits, the substance of the case. They disposed of the case on the substance. Now, I don't know, Bill, you've been involved in drafting. You had a case this year that you were involved in the briefing of it. I'm assuming every case that gets to the Supreme Court, all the lawyers involved, the court time, the clerk time, there must be millions of dollars that are being spent each time one of those 62 cases comes before the court. I'm just guessing, if you the hourly rates. And in the end, the courts say, well, you know, we're sending this case back for additional findings, or we're dismissing this on the basis of procedural reasons. Standing usually means, why are you the person bringing this? We don't want, you shouldn't bring it. Like the case we'll talk about, the abortion pill, right, was interesting. It was brought by a bunch of doctors who don't practice gynecology or obstetrics. They were just doctors. And the court said, what are you doing here? This doesn't even involve you, right? And so like, we're gonna talk about the abortion pill. If there's a problem, we want some woman who's got a problem because she got sick from this, not you. Why are you here? The problem that I think most people want to know is, yeah, I know, but what's the difference? If you know you're going to talk about this case, that case is going to come back. It's going to hold a new set of plaintiffs that are going to bring that case. A number of the cases that were decided this year that we thought went away did not go away. They're coming back. So maybe two of you are law professors and two of you cover the court, but maybe explain, because this, I think even, was it Alito and I think Sotomayor, someone said at some point, like, you know, why don't we just do this, right? I mean, this is just something it's right here, it's in front of us, we know what we want to say, let's go ahead and say it. What's the value of this incrementalism and this focus on procedure when in fact they might already know what they want to do?
Well, but so you need 4 votes to bring a case before the court, and you need 5 votes to win, right? So, I mean, we'll talk about, for example, the Moyle case, right? But I think that's a case in which kind of
This is the Idaho case.
This is the Idaho abortion
This is
case.
when I was telling you about the emergency room, where you come in and you get treated as if you're a patient needing to be stabilized, and it's not to save your life, it's to stabilize your health, and the state says you can only get an abortion to save a life, and now the court's basically saying, yeah, well, what about just stabilizing?
Right, so, you know, so that's a case where you basically, the court, and we'll talk about it, you know, in a lot of ways, but essentially it has kind of 3 wings. It's got the liberal wing, 3. It's got 3 conservatives and 3 real conservatives. and so, you know, the Moyle case is really one where it's kind of the left and the 3 moderate conservatives don't want to decide it. So, you know, they kick it back. And same for the abortion pill case. So, you know, and Roberts in particular doesn't want to move, in a lot of these cases, too far. So you'll have a case that comes before the court, but you have a big wing that wants to kick it back. So I think that's what we see in different
Well,
circumstances.
what was really interesting about the Moyle case was that you had 6 justices saying, we can decide this right now, right? 3 of them were on the left and said, the federal law called EMTALA that preempts the state law and these emergency abortions can be performed. 3 on the right said, no, the EMTALA has nothing to do with abortions and the state law can go into effect. And you had these 3 in the middle who said, you know, we're taking enough heat this year. We'll just put this one away. So, but both the Sotomayor, Kagan, Jackson side and the Thomas, Alito, Gorsuch side both said we have enough information here. There is a real conflict here, and the reason that that Justice Barrett, writing for the 3 who let's not do this wing, her reasoning was that. In oral argument, it seemed that the 2 sides were closer together than we had initially thought about what is prohibited and what is permitted. So we need more clarification from the lower courts, and that was a kind of a rare procedural thing. Don't you agree, Bill? I mean, usually you'll find standing or some.
Where they're simply saying we need more information.
Right. Well, what she said is, you know, at oral argument they changed where we were. So, you know, this hasn't gelled yet, right? But I think the larger thing that we have there is, you know, the Dobbs case, right? So basically, you know, Roberts said, we'll decide this narrowly. We're not at a point where we want to overturn Roe, right? And then you had the conservative wing said, you know, we're ready to overturn Roe, and they did overturn Roe. You know, one thing that a lot of people suspect, and I don't know, you know, if you think this is right, the reason why the Dobbs case was leaked was to freeze Kavanaugh.
That's what I think too.
You know, so Kavanaugh, I think everybody thought Kavanaugh's going to be the swing vote. You got the 3 liberals who are going to.
But leaking it would do what to Kavanaugh?
Well, because if it's leaked and Kavanaugh is saying, let's get rid of Roe,
Yeah.
then he's frozen. Then he can't change his mind because it looks like he's weak.
The chief was pressuring Kavanaugh at the time behind the scenes to sign on to a compromise. And so the leak had the effect of locking in Kavanaugh's vote with the 5-justice majority to overrule Roe. I think that's,
That's the story-
indisputable.
Yeah, that's the story that makes the most sense
right.
because, quite frankly, it seemed fairly clear that the chief wanted to do what he had always been doing with abortion. He wasn't ready to overturn Roe. What he wanted to do was just chip away and chip away and chip away. Because I think one thing that's relevant, it's important to remember, is the justices that actually come out of the conservative legal movement and the degree to which they quite possibly, quite likely view things through political lenses. And so I personally think, just from what I've read, that Roberts did not want to take the predictable hits that the GOP and the court have taken in the wake of Dobbs by overturning Roe. And to your earlier question about standing in particular, I certainly think that getting rid of an abortion case this year, an election year, on standing really takes the heat off the court and doesn't gin up the issue once again for voters.
So, but it's interesting to think about when Bill 2 years ago said they're going to overturn Roe v. Wade. I'm telling you right now, and I said, and the reason I didn't think it was going to happen is because the Supreme Court does prefer these incremental, small chipping away, right? I mean, people forget that Brown versus Board of Education, that case that ultimately overturned segregation in the school system, it led to the Civil Rights Act, the Civil Rights Movement. Thurgood Marshall argued tons of cases before the Supreme Court, all incremental shifts. And it's as if, he was able to see the field. And this is sort of what Supreme Court advocates do, right? That they think of, what I think is what's different is something what Bill said. It seems like the court is now more prepared than in prior years to swing at the fences, to take broader, what looks like political decisions. I think what Tiffany's saying is right, but it seems like the court is flashing something else, that we're willing to go out there, put it out there in a way that prior courts would have never thought of. We thought about doing it more incrementally.
So, but I think there's a split, again, on the conservatives. So Roberts is generally an incrementalist, right? So that's why he didn't want to overturn Roe and Dobbs. He wanted to chip away at it. Now, there's some things, though, where he's more aggressive. Like, he has always been deeply opposed to affirmative action.
Right.
So that was as soon as he had a moment to overturn affirmative action, which he did in
Remember, that was last year also.
And voting rights.
Yeah. Then he sees that. But on on abortion, he's very much incremental. So with Thurgood Marshall, the idea of essentially overturning Plessy, he litigated that for 14 years, right? And that's the kind of thing that I think that Roberts had in mind with overturning eventually.
That it would look like the Thurgood Marshall agenda, the way it looked, the game plan. Look, that it'll happen, but it'll happen over time.
But I think the lesson that the chief learned from being iced out of the majority in Dobbs, from being unable to take that incremental step, is it sure sucks to be dissenting. It is a lot more fun when I am in the majority and I get to assign the opinion and I get to shape the law. And I think what we have seen over the last 2 years is a less and less incrementalist Roberts, and a Roberts who is much more willing to swing for the fences, even when he loses Amy Coney Barrett, as he did partially or fully on a few of this term's major cases. The Chevron deference case, overturning Chevron, there was no groundwork for that. They didn't have a decision from a few years ago saying, well, we're cutting back on Chevron. They just didn't apply it for a little while.
We'll get to that, don't
and
worry.
now they're overturning it.
Well, I actually, and I want to hear what you have to say about this, I actually think what's happening with the Chevron case is really fascinating because it goes to what Roberts has done over the years, where he will issue one ruling that doesn't go as far as it could, but then the next year or 2 years later, he'll take the next step that one could have predicted based on what he did in the prior case. I actually think that he did that this term between Chevron and the name of a case that I'm losing right now on the last day of the term, where we'll explain Chevron.
Yeah,
you
let's-
want me to wait?
Yeah, let's
Because,
wait.
I want to get your thoughts
Yeah,
on this.
no,
because it
let's
has to do
definitely
with
come back to that, because
statute of
I got to
limitations.
explain Chevron to you and why that's important, and why even some of the other cases from this year, the SEC case, the in-house counsel case, even the banning of the bump stocks gun, that to me all needs to be talked about the same. So let's start with cases. Let's start with Jess. Why don't we start with you? Let's knock out the three, what I call the three Trump cases.
Okay.
The first one is the Colorado ballot case, which was decided 9-0. Colorado Supreme Court, I think you and Mark were interested in that. Maybe we'll talk. The Supreme Court of Colorado basically decided that the 14th Amendment, Section 3, is what's called, I guess, the insurrection clause. It said if you've taken an oath to defend the Constitution or as part of your public service, you will not engage in an insurrection. The 14th, 15th, and 16th Amendment, or was it 13th, 14th, and 15th, were Civil War amendments. 13th, 14th, and 15th were post-Civil War amendments. They provided rights for African and former slaves. And in the 14th Amendment, the Equal Protection Clause, there's this section, number 3, that was there really at the time to make sure that Confederate generals don't run for Congress, right? If you were involved in the Civil War, we do not want you in public life right now. So if you were involved in an insurrection, so a number of states, Colorado was the first one out of the box, and that actually the Supreme Court said, well, January 6th was an insurrection. We can invoke Section 3. You did it. That means you can't run for the presidency. And so this one's the Supreme Court. The Supreme Court ruled 9-0 in Donald Trump's favor. They spent very little time on it, and they didn't even wait to issue the decision. They issued it very quickly. So did they get that right?
Well, I'm quite sure I'm not. I'm quite sure that there's at least one person in this room who knows more about this case than I do tonight. But I will say this: when we had two Trump cases coming up around the same time, this Colorado case, Trump versus Anderson, and Trump's appeal of his loss in the D.C. Circuit in the election overthrow case, Trump versus United States. Some people in the Supreme Court press room sort of looked at it as, oh, this is a perfect Roberts type of situation because there are two Trump cases and there's one where there's very uncharted territory about enforcing this obscure clause of the 14th Amendment. The Colorado court was divided 4-3. Even it said they're not exactly sure how to apply this. That one, you could say, well, it's anti-democratic to take him off the ballot. That one, they can
Remember,
hand
a
to
number
Trump.
of other states were waiting in the wings.
That's right.
Hoping
That's
to do
right.
the exact same thing.
Right. So there were, this is, so that one, and yet the other one, the idea that the president could not be prosecuted for committing crimes while in office, or as the Onion headline put it, president cannot be prosecuted for crimes committed from 9 to 5, because only official acts were covered by the opinion. So that one looks like one that the court, following up on its decisions at the end of Trump's term involving the Cyrus Vance, the district attorney's investigation here, where they made or allowed the DA's subpoenas for Trump's financial records to be enforced.
So remember, those were the cases that ended up when the civil fraud case for the whatever 250 million or 550 million. The run-up for that was efforts by Cy Vance, the Manhattan DA's office, to get the tax returns and the financial documents.
Right.
All those tax returns, that happened last year's term, and that's what Jess is saying.
Well, yeah, that was the last year of the
Supreme
Trump-
Court last year said, no, there's no way, if Nixon had to give up the tapes,
Right.
Watergate tapes, you have to give up your tax returns.
Right. So it seemed that the stage was set to have, Trump wins one, Trump loses one. The court, shows itself as being very fair. They're just looking at the law. They're not playing favorites. But that's not actually what we saw. Not to cast aspersions on why they reached those decisions, but in both the Colorado case and the Jack Smith case, you saw the Chief Justice and his closest allies on the court go further than they had to decide those cases. They could have had a 9-0 opinion in the Colorado case that would have had from the most liberal to the most conservative member of the court signing on to it, and the Chief Justice and the others in the unsigned majority opinion chose to remove the enforcement power not from courts. They suggest that only Congress can enact a statute to enforce this 14th Amendment clause, and they got what Mark discovered through a careful assessment of metadata was a partial dissent from Justice Sotomayor, which was in some way converted to a concurrence, meaning we agree with the outcome but not with the reasoning. And Justice Barrett also criticizing the majority for going further than they had to go in helping protect alleged insurrectionists from the threat of losing the chance to be elected to federal office. And the same thing happened again with the Jack Smith case, as we saw again from a Justice Barrett concurring opinion.
So now that we open the door on that, we'll let everyone jump in on the immunity case too, since we've just started that. I think it's important to remember when Jess says, well, they went further on the immunity case, what they end up saying is you don't have blanket immunity, but you have presumptive immunity, qualified immunity for things that you do, not just 9 to 5, things that you do that look presidential, I think they said within the outer perimeter of your presidential duties, your constitutional duties. So I think everyone was surprised that when the court said, that means if you call up the Justice Department and you're the president, of course you're allowed to call up the Justice Department and talk to them. Even if you say, is there anything we could do about the election? Like it sounded like that's what they're saying, that if it looks like you're something, for instance, they even suggested, even when you called up Mike Pence and threatened him, you know, let's see if the lower court takes a look at that, because the president is allowed to call, if it's within the range, the scope of his responsibilities, the president calls up the vice president. And then they said also in that opinion that motive doesn't matter, which was shocking to say that Trump could literally say, look, my motive is to stay in the White House. That's my motive. But the Supreme Court said it doesn't make a difference. If I'm doing my job and my job allows me to call my vice president, back off. It doesn't matter what I say to him. And I think that that's what you're ultimately saying that goes much farther than needed to, created a, they even, I think, suggested, my favorite part of the opinion, that as if to say what Donald Trump said on January 6th, forget the First Amendment for a second. Yeah, First Amendment. But he's also the president. And because he's the president, if 35,000 people show up to the ellipse, he's got to go talk to them.
So, right, the bully pulpit, just like he could say, please buy war bonds, that kind of thing. He can also say, please fight like hell to, that kind of thing.
Just a quick point I want to make about both these decisions. These were very rushed opinions. The Colorado case was churned out in about a month, so they could get it right before the Colorado primary. The Jack Smith immunity case was churned out in about 2 months. It was the last case that they heard for oral arguments. The sloppiness and the rush to the finish line in both cases really comes through. And I think what we get a glimpse of is the women of the court attempting to broker some kind of compromise to make the majority decision not go as far as it does, and failing, and seeing some evidence of that slip through the cracks. So yes, Jess is correct. I discovered in the metadata of the Colorado opinion, Justice Sotomayor's opinion that was eventually labeled as a concurrence and signed by all 3 liberals was actually originally labeled as a dissent. At some point, it seems like she was trying to dangle the possibility of what she would call it to secure some kind of compromise from the majority. That fell through, and they pushed it out without even checking the metadata. And in the Jack Smith immunity case, Justice Barrett has this very strange concurrence where she disagrees with a huge and super controversial point that the majority makes, which is that you can't introduce evidence of official acts into a trial. You can't even tell the jury.
No, it's 2 things. If you can't indict someone for that act, you can't use the evidence of that.
Right.
You can't indict them, and you can't even use the evidence of what.
So Justice Barrett disagrees with that. She says you should be able to show the evidence to the jury. You should be able to bring all of that in. Just tell the jury, you can't indict based on this one thing alone. Whatever. You can't convict on this one thing alone. But you can tell them the thing happened. And yet she purports to join most of the rest of the opinion, and she calls it a concurrence. And so it feels like what we're seeing is that the 4 women are around the edges saying, let's let up the gas a little. Let's figure out how to make an opinion that doesn't look rushed, that isn't so extreme. I think both of these, the majority opinions, went way farther than they needed to, answered way more questions than they had to, tried to lay down these principles that frankly seemed designed to insulate Trump from a lot of consequences. And the 5 men in the majority just said, no, we're going for it because we have the votes. And that's a big part of what I mean about Roberts no longer being an incrementalist. He is powering those 5 men to, I think, a new kind of far-right position where they seem prepared to kind of lay the groundwork for a second Trump term and to make Trump a lot more insulated from accountability in a second term than he was in his first.
And just very quickly, the fact that all of that has happened really does make the question of character in the president so much more critical, so much more important, because if you have a despicable degenerate who is your president, well, that's a problem when that particular person has the kind of immunity that the Supreme Court just extended to him. Whereas if you have a person who's actually a decent human being, and I'll be transparent, I'm a liberal, but I don't think that, could you guess? I don't think
Wait, you and Mark?
I don't think that it's just Democrats. I mean, a guy like Mitt Romney is not going to abuse that sort of power. But there are people, of course, who will, and that is a big part of the problem with this decision.
But I mean, so one thing that's important to keep in mind is how much the law changed because of the decision in the Trump versus United States case. So before Trump versus United States, it had been kind of well established that the president was not immune from criminal law. So when Nixon told the CIA interfere with the Justice Department, nobody said that's an official act, right? Nobody said that.
Even though that's the kind of call he can make.
So under this decision, right, John Dean said Nixon would have walked, right? So that's a change. And I in personal experience, so I worked, as a young attorney, I worked on the Iran-Contra investigation. And one of the big questions was, did Ronald Reagan break the law when he provided, arguably, support for the Contras and Congress said you can't do that? That was the big question. Nobody ever said that's an official act. The criminal law doesn't apply to him. Nobody said that. And when I was at the Justice Department, I worked on the 2 big questions about can Clinton be tried for a crime after he was acquitted by the Senate in an impeachment proceeding, and can he be tried as a sitting president for a crime? The Justice Department did 2 big decisions on that. Nobody ever said the president can't be tried for a crime. Nobody said that. So this is a case in which the Supreme Court established something that is at odds with 200 years of understanding.
But the court also, to be fair, mentioned Nixon versus Fitzgerald. Now you might say, who cares? Now Nixon versus Fitzgerald was when Nixon left office, some disgruntled member of the Defense Department, I think he got fired from the Air Force, was pissed off, and he decided to sue the President of the United States for damages in civil courts, not a criminal case, in civil courts. You owe me money because whatever policies you undertook, I ended up getting fired. And the Supreme Court, in this decision, mentions this, and I'm wondering whether you think they should have mentioned this. They clearly used it. They leveraged their decision by saying, the Supreme Court said you can't sue a president when he leaves office. For God's sakes, he'll spend his whole life in civil court. And the Trump lawyers were saying, well, the same thing applies to criminal court. All vindictive prosecutors will be prosecuting the president for the rest of his life.
Yeah, so first of all, just to go back, Alexander Hamilton in the Federalist Papers says the president is not a king. Mm-hmm. And if the president breaks the law, he can be prosecuted. Okay? He says that very clearly in the Federalist Papers. Nobody ever thought the president could not be prosecuted for a crime until last month.
So I'm just saying, the civil court
yeah, so
to
the
you,
civil
you don't
totally
care,
different.
right?
No, of course I
No, I know.
care,
I'm just saying.
but it's
no, I'm
totally
just saying you
different.
don't think it is relevant to this decision.
It's totally different. Civil, the point of the civil case of Nixon versus Fitzgerald is everybody can sue the president because of some claim of civil wrongdoing, right? Prosecutors, there are a limited number of prosecutors. It's not the same thing. So the balance is totally different. And again, the basic point is the president is not above the law. The president can't break the law. The president can't commit crimes until now.
It's really shocking in a lot of ways. I mean, so I teach constitutional law, and there are a lot of changes that I always have to make to my class just because this area is in constant flux. But I'm changing the beginning of my class this year because we've always just assumed that the president was not a king. And now I can't I wouldn't even have to represent that to my students because they all knew that. That was just sort of background knowledge that they walked into the classroom with. But now we actually have to grapple quite seriously with this notion that there is some carved out piece of protection, some immunity, where presidents can no longer be prosecuted. And what does that mean when you think about what the Declaration was really all about?
So,
Well, one interesting thing, during Justice Kavanaugh's confirmation, this is around the Mueller investigation time, one of the questions he was asked was, about the president's criminal liability. And then, before the Senate Judiciary Committee, his answer was, well, I know that there's a question about whether the president can be prosecuted while in office or whether that would have to wait until he leaves office. I mean, the way they answered the question seemed to be that was really the dispute. Is it possible at all? Now, Justice Department policy is to not prosecute a sitting president. No other entity would have the ability to do that. But was that a legal requirement or simply a policy decision? And the way it seemed from the way he answered the question was that really, of course, it's, if you can't do it while he's in office, you have to wait till he leaves.
but that's not how he voted.
That's
All
not
right,
how he voted.
I want to finish off, Mark, unless you want to add
Yeah, I'm fascinated to watch this because, you guys, Bill Traynor is the calmest and most even-tempered person I have ever met. You have to be a dean and deal with law professors all day. When a Supreme Court decision makes him this angry, you should be scared shitless. I just want to drive home that point to everyone. Like, my alarm level at this was high, and it is now through this roof.
Did you see his face when I said Nixon versus Fitzgerald?
I just want to make one
that I
point.
brought up the civil case.
I think this is implicit in what you two were saying, but I mean, the Trump immunity decision is not law and barely pretends to be. It is policy through and through. It is the justices saying, you know what, we think it seems like a really good idea to give the president near total immunity from prosecution because we like the president, we like this particular one, and we think we should enshrine into law this extremely contested, newfangled vision of monarchical immunity because that's how we want the government to function. And I just think that is also kind of what the court did in Nixon versus Fitzgerald. It was very much a policy decision, but this court purports to loathe that kind of policy making. They say, we're originalists, we follow history, we follow the law. There was no law in this opinion.
All right, before we move on, I want to quickly finish the third Trump case. It's really not Trump case, it's really all the people. It's around 350 people. Remember, January 6th, around 800 people are arrested and prosecuted. Most of them pled guilty to various crimes. 350 of them are still in jail, by the way. They're for resisting arrest, destruction of federal property, trespass, and then this thing. Here's this thing, the disruption, interference with a federal meeting in progress. Some meeting that's in progress and you disrupted it. The counting of the electoral votes is a federal meeting, and so therefore you all plead guilty to this, or we're prosecuting for this. And this is in the Jack Smith case. That's one of the charges against Donald Trump. It hasn't been prosecuted yet, but that's why it seems like it applies to him, although it hasn't. And Bill, if you could just briefly take us through this, because the answer, I know that did you file a brief in this case? No, that was the other case. Because this case, essentially, that law came out in the aftermath of the Enron scandal. And it's seen as a corporate malfeasance law about the destruction of evidence in a corporate fraud case. And so the Supreme Court basically said, what does this have to do with the counting of the electoral votes? That is a federal meeting, yeah, but this is not about the meeting, it's about the destruction of evidence, and people running around threatening to hang the vice president is not the same thing. They affected the meeting, and I wonder, so that case got disposed of, and I think in a surprising way, because everyone had counted on, well, all these people are in jail, they pled guilty to doing this, and now the Supreme Court is saying, yeah, but you shouldn't have, because it's not a crime, it's not that crime. It requires, now they did suggest, I don't get it, if they destroyed evidence somehow while they're rampaging through the Capitol, I'm not exactly sure how that plays in, but I'm wondering whether anyone
Yeah,
quick.
so, I mean, I don't know about the rest of the panel. This is one I'm not so exercised about. So, in the wake of Enron, evidence was destroyed. And the law at the time said the people who advise the people to destroy the evidence, they're criminally liable. The people who destroyed the evidence aren't. So this statute was passed in the wake of Enron, and the way it's written, it's basically to destroy evidence or otherwise interfere with a proceeding, right? And the question is, what does otherwise mean? And that's where the courts split. You know,
Right.
is otherwise, like
About
destroying evidence,
is it
or is
about
it
the
just?
meeting?
Didn't you have
Yeah.
Justice Jackson in the majority on that one too?
So this is one where, again, so Justice Jackson took the position that, essentially took what would be the anti-Trump position. In other words, she said, there basically are two, it's got to be like, the majority said, it's like destruction of evidence. This is not like destruction of evidence. So now, and Jackson dissents. I'm sorry, Barrett dissents from that.
Barrett dissents, but
Right.
Jackson joins the
Joins the majority. So I think this is one that I think
You're not
frankly
troubled
think-
by that,
I'm
is
not
it?
troubled. The other thing that I think it's important to realize is, first of all, almost all of the January 6th prosecutions, there are multiple charges. So even if this one goes away, virtually every case.
Yeah, I mentioned, I
has
rolled
that.
out the
Yeah.
the various things they pled guilty.
And also, it's not clear, there's a debate about whether you can actually, even under the Supreme Court's theory, you can prosecute Trump because essentially filing false elector documents is like destroying evidence. So this is, I'm
That's-
very exercised
even
about
though,
the immunity
even
case.
though
This
he,
one I'm not so
you're
much.
saying even though he wasn't running through the building, you could say, well, he did he did something with evidence. All right,
He screwed up evidence.
all right, let's move on to the Chevron case, because this picks up a number of cases.
What about the fourth Trump case? Trump too small.
Yeah,
Just very quickly, trademark case. The Biden administration defended the interest of Donald Trump.
Oh, right.
Said you cannot trademark someone else's name for your own private use. And somebody was selling shirts that said Trump too small. So you had there
Had a hand gesture like that.
yeah. So anyway, that was a win for that one. Biden and Trump were in lockstep on that.
Well, what was interesting.
Chevron case. Chevron case. So this is important because it even involves other cases. So the Chevron deference case is about a principle that's been the law since the 1980s, right? And the principle basically says that if there are any federal regulations where there's any ambiguity, the courts will defer to the judgment of the agency itself. Now, so that could be the EPA, the FDA, the FTC, the SEC, all of these agencies. What's important to understand is that we've had this discussion over the last several years. What's the discussion? This Roberts conservative court really despises the federal agencies. They don't like what's called the administrative state. They're saying there's three branches of government. The agencies are in the executive branch. Laws are supposed to be passed by Congress. All these guys have is PhDs. People have sometimes.
I would defer to them.
Sometimes people with PhDs doesn't make them right or good friends either, because they lord it over their friends. This is an anti-PhD rule. The deference is saying, who are these guys that went to Ivy League schools, and yeah, they know something about drugs, but it came up literally in the Texas abortion case, where a federal judge in Texas said, I don't like this abortion pill at all, and I don't think it's safe. And they're going, what do you mean? 80% of the world uses it. I don't care. More than 50% of the women in the United States use it. I don't care. The FDA rushed it, and more work needs to be done on it. That's what that case was about. To me, that represented exactly where we were headed with the overturning of the Chevron deference. That we saw a number of cases, even this term, right? They struck down, the SEC used to have their own in-house tribunals. And this court said, no, you don't get your own courtrooms. The EPA said, well, if you're a polluter and your pollution takes downwind, goes to another state, you're responsible for the damage done to the other state. We have PhDs, we can tell you that the wind did this. And the court said, no, who are you to do this? And by the way, the Chevron deference case was about what, herring fishermen? Right? Literally, that's what it was. It was not Chevron. They overturned the deference on a bunch of herring fishermen that were told by, I guess, the EPA?
National Marine Fisheries Administration.
Right, exactly. Said, you need to have monitors on your, we have to make sure that you don't overfish herring, and you have to pay for the monitors. And the fishermen said, no, we're not paying for the monitors. And so this has come up a number of times over the last few years with workplace protections, with drugs, with the COVID vaccine, right? You can see how this plays out, right? Conservatives think the COVID vaccine wasn't handled right, and we think we gave too much power to Fauci. So this really speaks to a much broader question.
Well, Thane, what's really interesting about this case is that the original case, which is called Chevron versus Natural Resources Defense Council, it actually was a case pushed by the Reagan administration. What happened was that the Reagan administration was very deregulatory, and they were paring back on environmental regulations by the EPA. In fact, this case involved Justice Gorsuch's mom, Ann Gorsuch, who had been the administrator of the EPA. And environmental groups like the NRDC were going to court saying that these agencies are not following the law and they want a court order to reimpose certain kinds of environmental regulations. And at the time, the federal judiciary was much more liberal, and in fact, I think future Justice Ginsburg was on the panel that was overruled by the U.S. Supreme Court in 1984. And what the court said was, an opinion, it was a 6-0 court. There were 3 justices who had to sit out, but it was an opinion by Justice John Paul Stevens, which said that courts are not experts in these fields. Courts don't have any kind of democratic accountability. So when there is an ambiguity in the statute, maybe it's left ambiguous on purpose by Congress, maybe it's an accident, but when there is ambiguity in it, the court should defer to the reasonable interpretation of that administering agency, because there's some accountability to the people through the president, and they have some expertise in it. And then that was something that was, it helped the deregulatory movement go forward without being second-guessed by judges. But that changed over following years when Congress was gridlocked. There were not a lot of new laws being written that addressed issues, and particularly Democratic administrations, Clinton, Obama, and Biden also, began using regulatory power to address new issues that were arising, and then courts were deferring to those agencies. So that is what really got a lot of the business community unhappy.
And the conservatives were saying, who are you guys?
Right.
Who are you? Isn't this a congressional responsibility?
Right.
Who is you guys? This looks like the fourth branch of government works as an agent of the executive branch to create laws, when in fact the lawmakers are supposed to do that.
I want to tell a little story that I think illustrates the problem here. So the decision overturning Chevron comes down on a Friday. The Supreme Court says, unelected judges know better than the experts at federal agencies. We can decide if the science is correct. We can decide if the regulation makes sense. We can decide if you fit into what Congress requested, whatever. We'll be the ones to make the call. The day before, on Thursday, the Supreme Court issued a 5-4 decision blocking a major EPA regulation limiting pollution from upwind states to downwind states. In that opinion, authored by Justice Neil Gorsuch, Gorsuch confused nitrogen oxide, which is the regulated pollutant that causes smog, with nitrous oxide, which is laughing gas, 5 times in his opinion, and issued opinion that instead of purporting to limit regulations of nitrogen oxide, limited regulations of laughing gas. If that is not a good example of why we should not be entrusting unelected judges to be deciding and overruling the determinations of experts at these agencies, I just don't know what is.
I'll actually offer another example.
Yes, a fan favorite.
Are there any tax lawyers in this crowd? Any tax lawyers here?
I'm so sorry.
Okay. One of my very best friends is a tax professor, and we talked about this the other day, and I asked her, how often do federal district courts screw up the interpretation of the Internal Revenue Code? Well, when you think about the impact of a case like Chevron, where just judges are now saying, well, you guys, we judges, we're the ones who are going to figure out what the ambiguities mean when you don't actually understand tax law. That's a problem. I mean, one of the things that's so interesting to me about Chevron is the enormity of the decision. I know that there are administrative law scholars who think it might not be quite as big of a deal as a lot of us think it is, and I totally respect that. But I also think that the public doesn't quite understand just how much of our life is governed by administrative regulations. And so it's really quite important that there are district court judges and circuit court judges who are now going to be in charge of determining whether or not the agencies did what they did properly based on an ambiguous statute that they themselves don't really understand. And the example that Mark gives is really just a perfect example of what the problem promises to be.
And I think the other point to remember is this is part of a larger campaign. So as Thane said, you have in this term a number of major decisions in which the court strikes down things that administrative agencies have been doing forever. So the SEC has a civil fraud investigation, which they...
Well, the bump stock.
Right. So, but let me...
Right, yeah.
I mean, the bump stock, I think, is more like a Chevron case in terms of, these are people who know about what's a machine gun, the government regulators. But what you have, setting that aside, is you have a pattern of cases in which you have kind of well-established economic regulation, which the Supreme Court is now nixing, right? So the SEC does civil fraud with an administrative law judge rather than a jury. That's gone, right? And so Chevron is, again, regulators determine what the rules mean, and now all of a sudden there's no deference to them whatsoever. So it's a significant decision, but what's even more significant is it's part of a larger pattern.
And again,
also-
all the agencies that we're talking about, it's like the IRS, the FTC, all of this. You have one last thought,
Yeah,
Tiffany,
really
we got to
quickly.
move on.
I mentioned earlier what some people think of as the Roberts two-step, where he will write an opinion one year that sort of lays the groundwork for a more significant decision that's going to come up later on down the line that happened, for instance, in the voting rights context. But I think this term, we saw that two-step kind of happen with Chevron, the overturning Chevron in the Loper Bright case, where Roberts tells us, we're not actually going to overturn every single regulation that existed. So calm down, everybody. It's not going to be that big of a deal. And then we get an opinion on the last day of the term where the Supreme Court said that the statute of limitations for challenges to regulations will run from the date of injury as opposed to the date of issuing the regulation itself. What does that do? It potentially opens up all the regulations to challenge that Roberts had literally just told us would not be reopened. And so it's really extraordinary to see the way that this particular court is taking a sledgehammer to the administrative state.
All right, let's move on to the gun cases. We got to get moving. There are two gun cases. They're decided differently. One of which, that's why I said bump stocks, oddly enough, that was a regulation from the alcohol, tobacco, whatever, that entity that handles it. Basically, there was a ban on bump stocks because there is a federal law that says that people are not permitted to have machine guns. And even in the context of the two major Supreme Court cases that we've heard on the Second Amendment about the right to have a gun individually for self-defense purposes, and then more recently the case you can even go outside with it as long as concealed, the Gruen case, there always was this federal regulation that said, yeah, but not machine guns. Machine guns is something else. And so bump stocks somehow convert a regular semi-automatic rifle with a trigger, and it's like the old show, The Rifleman, from the 50s and 60s. Somehow you take an old rifle and you fire lots of bullets. And so the argument was, well, if you can fire lots of bullets, it's a machine gun, and it should be banned. And the Supreme Court ultimately said, no. It's not a machine gun. It's not built. It's the trigger. They made a distinction between the trigger finger and the gun itself, and the gun itself is not a machine gun. The second gun case, and then you can all jump in, the second gun case had to do with restraining orders and protection orders for people who have committed domestic violence. And the argument was that if you have such a restraining order against you, you're not allowed to have a gun, right? Maybe you are, as a human being, have a Second Amendment right, but you have a disability now. Your disability is that you shouldn't have a gun. And the court ultimately, in that instance, ruled in favor of the rules banning, disqualifying the ownership. And that, I thought, was interesting because it's a conservative court, and they were coming out in favor of, essentially, in favor of women who were saying, you can't let my old boyfriend have a gun. He'll kill me. And so the conservative court actually stepped in this instance. And so I don't know if you think that on the one hand, they said, no, if you want a bump stock, you want a gun that fires lots of bullets, good luck to you. Go hunting. But if you have a protection order against you, no, you can't even have a small gun.
I mean, I think that it's really interesting when you look at what was happening in the lower courts as they were attempting to implement the Bruen decision. The Bruen decision was the earlier decision where the Supreme Court essentially said that if you're going to have a regulation of the Second Amendment, it has to be consistent with the regulation that existed from a historical perspective. But what does that actually mean? Does that mean that if you have a restriction on people who are dangerous owning a firearm, do you literally have to find the same kind of restriction that existed in 1791? No one cared about domestic violence in 1791. So, I mean, this is part of why it was so dangerous. And when you look at what was happening in the lower courts with a lot of these challenges, these district court judges and the circuit court judges, they were so confused, and some were really angry. I mean, they were saying, how am I supposed to actually take seriously what you're saying about history and tradition? Do I need to hire a PhD clerk who's got a PhD in history? Or yes. And, is that how I'm supposed to interpret these cases? What is it that I'm supposed to do? And so you saw so much turbulence in the lower courts that I think that may have potentially had
Well, one thing
impact.
that was really interesting is that, most of these cases that moved along these dramatic ways, they don't just occur organically. Maybe sometimes they do, but often they are engineered to present an issue and to have a very sympathetic plaintiff. And this is a very long tradition. Plessy versus Ferguson. Homer Plessy was chosen to test this. It didn't work out, but the idea was to test a segregated railroad car law. So this is a very long tradition where test cases are invented or engineered to present a very appealing package to the court. And that's happened in the gun cases. The gun movement has had, tried to find extremely law-abiding, sympathetic people. This was sort of the Biden administration kind of beating them at their own game, because in these trailing cases of Bruen, the Solicitor General had a number of ones involving different statutes and rushed to get this case before the Supreme Court because Mr. Rahimi, the individual involved, was about the least sympathetic person you could possibly find. The guy had brandished a weapon and hit his girlfriend, and he had shot up a Whataburger, and he had done all kinds of things that led to that violated state law, that led to the imposition of a separate federal law that says if you're under a state domestic violence restraining order, then you cannot possess a firearm under federal law, and that's a law that dates from the 1990s. So the issue here was a family court judge issued this restraining order, he accepted it, but he had not been convicted of a felony or crime when that order was issued. And so his Second Amendment argument was I'm presumptively innocent. The civil order, that I didn't have a full trial. I shouldn't lose my very precious Second Amendment right based on that.
From a Supreme Court that has relaxed those rules and has said, I can even walk outside with my gun as long as I don't show it.
But I think the gun movement is very unhappy that this was the case that got to the Supreme Court. And
because the optics were so terrible.
Right. I mean, it's the worst possible criminal defendant from the perspective of the gun rights. Because he was shooting everywhere.
You actually wrote the.
So I wrote an amicus brief.
He actually wrote a brief on this case.
Right. Yeah, absolutely.
Yeah.
But the question is, so the Supreme Court in the Bruen case says, you decide what the Second Amendment means by looking at the history and tradition, right? And so then there are two ways to look at that. Do you look at, is there something exactly like this where the state said you can't do this? So did the state in 1791 say a man who's guilty of domestic violence can't have a gun? No. You know, I mean, it was women had no rights that the law was recognizing. So of course there was no protection, right? On the other hand, there are laws that said somebody who's dangerous can't have a gun. So do you look at the micro or do you look at the broader principle? And this was a case in which 8 votes for the Supreme Court said you look at the broader principle rather than the micro. So we'll see where it goes in the future, but that was, you know, I think that was an essential decision because otherwise you basically would have no gun control regulation in the country if you're always looking at
Yeah,
the
but
micro.
you know, this is something I've always wanted to ask you. So I brought up the Rifleman before. Everyone has watched movies like Wyatt Earp, and you know, we all know in the 19th century, sheriffs would occasionally tell people, you know, no guns in our town, right? And now I don't think that's just fictional on Gunsmoke and Bonanza. I know you're saying it is actually fictional. That never happened. I'm wondering, is Clarence Thomas saying, look, if there are references around the country where sheriffs said you can't take a gun into the saloon, you can't take a gun in Dodge you got to give me your holster, and I'm wondering whether that's what we're talking about.
So, I mean, so one of the things so the Brune decision is the one that transformed the Second Amendment law, right? And it's the one where Thomas creates this test where in interpreting the Second Amendment, you look at history and tradition. But then he also, if you're a legitimate originalist, you look at what did the words mean at the time the Second Amendment was adopted. But Justice Thomas looks more like Thane and the Rifleman. It's like, you know, in the 19th century, there were regulations of people in Cody, Wyoming.
Yeah.
For an originalist, that's irrelevant. And that's one of the things that actually Justice Barrett really focuses on. She says to him, if you're an originalist, you got to look at 1791. You can't just pick and choose, you know, gun regulations or absence of gun regulations over time. So that's one of the things that she does, because she is really taking history and tradition seriously.
I've never been more happy that I mentioned Rifleman, because it actually was relevant. All right, there's 2 more cases I absolutely want to get to, and I know, Tiffany, you're interested in those 2 cases. Let's first the case about homelessness in Oregon. The Ninth Circuit, which is a notoriously liberal court. You're talking about Los Angeles, Portland, San Francisco, West Coast cities with very large homeless populations, and they don't know what to do about it. And they've been using anti-camping laws to dismantle campsites on beach in Santa Monica in Los Angeles, and are basically arresting people. And the Ninth Circuit, predictably, as a liberal court, said that violates the 8th Amendment. Right? That's cruel and unusual punishment. You can't arrest someone for sleeping. They have nowhere else to go. You can't do that. And the Supreme Court essentially said, what do you want us to do? We're not going to tell cities what to do, especially liberal cities obviously have their own problems, and this is a municipal decision, not a constitutional one.
I mean, it's a very interesting case along a number of dimensions. You know, the city of Grants Pass in Oregon, they have this law. You can't sleep on the streets. You can't sleep on the sidewalks. You can't sleep in public parks. The first time we catch you, we'll give you a fine. The second time, we can arrest you. And they're trying to, of course, respond to how challenging the homelessness problem is, especially when you think about people who urinate on the streets, people who in some cases defecate on the streets, people who, the crime, for instance, that can sometimes be attendant to the homelessness problem. And so, you know, when you combine that with the fact that there weren't enough beds in emergency shelters in the town, there really was no place else for these people to go. And so the question before the court was whether or not this rule violates the prohibition against cruel and unusual punishment. And the court says, well, I mean, perhaps colloquially, this does feel cruel, but when we again look at history and tradition and we think about the kinds of punishments that really were cruel and unusual, no, criminalizing an action, namely sleeping on a sidewalk, sleeping on the street, etc., that does not seem to rise to the level of what constitutes a cruel or unusual punishment. But Sotomayor, in her dissent, makes the point everybody has to sleep. It's just a human thing that happens. And so eventually, you're going to arrest someone for doing nothing more than being a person. And what that did for her purposes was transform this law into a status-based regulation. And those are the kinds of laws that really aren't constitutional. You don't criminalize the fact that someone is who they are. Classic example that the court talked about is criminalizing someone for the status of being an addict. And
Well, I'm sorry, but isn't there the distinction between being able to change your status and not being able to change your status? In other words, you could eventually not be homeless.
well, I mean, that's kind of aligned with what the majority was talking about in that case, because they were focusing on the action of sleeping as opposed to, or being involuntarily homeless, whatever the case might be. The action of sleeping versus the status of being homeless. And they were saying that the law does not, in fact, target the status of being homeless. It simply targets the act of sleeping in a place where you're not supposed to be. And so, on the one hand, the read that the majority gives, from my perspective, is not an unreasonable read. But it does, at least from a colloquial perspective, from a moral perspective, it feels deeply cruel. Precisely because everybody has to sleep. So,
Well, one great thing about this opinion is to see Justice Gorsuch extolling the jurisprudence of Thurgood Marshall, because what happens is that the case that Tiffany's talking about, this 1962 case, Robinson versus California. California had a statute; it's illegal to possess or be addicted to narcotics, and there was no evidence that this defendant Robinson possessed narcotics, but he did have needle marks on his arm, so there was evidence that he was an addict. So he's convicted of being addicted to narcotics. And the Supreme Court in 1962 said, well, there's no punishment would not be cruel, just like punishing someone for having a cold. Now, if they had found drugs on him, that's different. But his status of being a drug addict, meaning he must have used them at some earlier time, that's what you can't criminalize. But the court did not go further. In 1968, and this was the opinion that Gorsuch mentions again and again and again, and mentions and name checks Thurgood Marshall repeatedly, there was an argument that being drunk in public, same thing, cruel and unusual to punish me for being drunk in public. And the court, and this plurality opinion by Thurgood Marshall says, well, maybe if it was just being drunk, but being drunk in public is not a status. You don't necessarily have to be in public. Some of us like to drink alone. There's other ways to do it. And so that was sort of the end of the line, and the Supreme Court did not extend this status use of the Eighth Amendment, which is mainly focused on punishment after you are convicted of a crime as opposed to crimes in general.
yeah, one of the things that was interesting about this is they kind of hinted at the possibility that maybe there was a due process question that was at stake here. In other words, when you're talking about a due process question, to put this very colloquially, you're kind of asking, is it fair? And maybe there is an argument suggesting that these kinds of laws might violate the due process clause. I think there are going to be
Meaning not a cruel and unusual punishment,
Yes.
but a fairness.
That's right.
Okay.
That's right. And I think that there are going to be some interesting and hard due process questions coming up in the next couple of years having to do with fairness,
All right.
especially in the abortion setting.
Let me ask one more question, and then we'll take some questions, and we'll say goodnight to you. I'm interested in the Sackler-Purdue Pharma case. That didn't get, in my view, enough attention. It's enormously interesting. This is in the aftermath of the opioid crisis. Purdue Pharma goes out of business. They're bankrupt. But the people that own them, the Sackler family, are billionaires. I think there was a book about them. There were several different TV shows on Hulu. Everyone had something about the Sackler family and the opioid crisis. This crisis has been going on for 10, 20 years. There are cities that need money. There are people, families that need money. And the Sackler family said, I'll tell you what, if you give us immunity from any civil liability, we'll give you $6 billion. And if you add that to the other, it's $10 billion. You got $10 billion, good for you. Distribute the money, the bankruptcy is over, and we're done. And then the question is, yeah, but why would we grant you a release? And the Sackler said, because we're not writing you a check unless we're going to give you $6 billion unless you tell me that we will never see inside of a courtroom for this again.
Yeah.
And so it's an interesting case. It's a moral question, right? And the cities are saying, give me the money. I want the money. The money is there. I want it. And the court said no, right?
This is one of those cases where I think the moral question cuts both ways, because what you have here is, for those of you who understand the way bankruptcy law works, you know that when you file for bankruptcy, long story short, essentially, an estate is created, and once everything is confirmed, for the most part, you are shielded from having to pay any of the debts that you had, the debts that sent you into bankruptcy in the first place. But in order to get that extraordinary amount of protection under the law, you have to really expose everything about yourself financially. And so what the Sacklers were doing was, one, between 2008 and 2016, they milked 75% of the profits from Purdue Pharma, and they sent it abroad. They put it in offshore accounts. They put it in places that were hard to find. But two, that obviously weakens Purdue Pharma, which is what sends Purdue Pharma into bankruptcy. And so what the Sacklers did was they said, look, we don't actually want to expose ourselves by filing for bankruptcy. So instead, what we want to do is this. We want the bankruptcy court to agree to give us all the protections that you get under the bankruptcy code without us actually having to file for bankruptcy, including the litigation protections that we would get. So we're not going to be on the hook for any of the claims that have currently that are currently proceeding against Purdue Pharma, and we're not going to be on the hook for any future claims that come up as well. And so on the one, and in exchange for that, we'll give you these billions of dollars. So on the one hand, you can see why, as a policy matter, it makes sense to just let this be done. Let people get their money because this crisis has been debilitating, and people need to recover, communities need to recover, and if anyone should be paying for it, the Sacklers ought to be paying for it. But if you let the Sacklers off the hook like this, there's more money you might actually be able to get from them. And so that's why it's really troubling to read the bankruptcy code in a broader way than is actually necessary to extend this protection for them. I mean, just one more point I want to put on the table.
Just to be clear,
Yeah.
because the bankruptcy code does not call for a release. Doesn't say, oh, and we can release you.
Mm-hmm.
Right.
And not only that, but the creditors, they didn't have to consent to it. And so you have this non-consensual release that would have allowed the Sacklers to walk away with the lion's share of their money without having to face any more litigation or any more challenges to their status.
But everyone on this, hold on, Bill, everyone on this stage, and those of you here who have been involved even minimally in the legal system knows, and this now sets a new clock that could be years, right? So we're talking not more weeks, but years. And the places that are saying, but we need the money now, this is, yes, it's a moral question, we get it, but we have needs now, and we know what the legal system does. It takes its time, and we don't have that kind of time.
And that's
Bill?
the fight.
Yeah, so one of the things that's interesting about this case is basically all the cases we've been talking about have a basic right-left split. There's some exceptions, so Justice Barrett in the immunity case, Justice Jackson in the obstruction case, but they're basically right-left splits. This is not a right-left split, right? So you have Gorsuch for the majority is really doing what he traditionally does, which is this is his reading of the statute. Textual, right? And Kavanaugh for the dissent is saying people are going to be, the kind of thing you were saying. People are going to be waiting forever for money, and we've got to move quickly. So one of the things, again, that's really interesting about this is this splits both the conservatives and the liberals, because on one hand you have how do you read this text, and on the other hand is people are in crisis and they've got to have some remedy.
All right, read 2 questions from the audience and say goodnight. Smarter, right? Everybody, did we deliver? Lots to talk about. And so, yes, you guys are awesome. 2 questions from the audience. This comes from Sean Rennington. I don't know if this is someone here or someone online. am I right that the Supreme Court can legally accommodate 2 or 3 more justices? And what would that take? And can a president do that?
Why stop with 2 or 3, Sean? Sky's the limit. Look, the Constitution does not set a number of justices. It's gone down, it's gone up. It's been at 9 for about 150 years, give or take. Congress is free to add seats and allow the president to fill them at any time. And so when, President Biden got into office and there was a lot of chatter about court expansion, I think even opponents recognized that would be constitutional. Would it be right? That's another question. But yes, absolutely, there could be justices added, even for the express purpose of changing the outcome. And as long as you do it through a law with a majority vote in Congress that the president signs, then that's that.
So, Bill, go ahead.
Really quickly, another alternative, because that's going to obviously be very difficult. We used to have Supreme Court justices do something called riding circuit. And essentially what that meant was Supreme Court justices would go down to the circuit courts and they would sit in there, and you could bring up circuit justices to sit on the Supreme Court. So perhaps one might revive that practice too. It's unlikely, but certainly theoretically, if you're thinking about how to try to adjust the dynamics on the Supreme Court, that's certainly an idea that's also in the mix.
So, Bill, I know Bill, if you can help us with this. Everyone's heard of the Franklin Roosevelt court packing, right? So we know how that ended up, and in fact, eventually he gets the court that he wants anyway. But how did the court actually move up? Because Mark is right. At some point there was 7, then there was 8. Like, what happened, and how did? I mean, we know about the court packing scandal, but how did it get?
Scandal is that's
right.
That's outcome determinative.
It looks better and better in retrospect.
Yeah. No. So I mean, it's something that we really have seen throughout the history, right? So, going back to John Adams, second president, he loses to Jefferson, and the Federalists in Congress say, you know what? There's a vacancy on the Supreme Court. We'll drop down the number of Supreme Court justices because we don't want Jefferson to fill it. So they pass a statute, and then Jefferson comes in with the Republicans, and they say, no, we want to fill it. So they go back up. So it really is something that has been...
And that was the first time anything like that happened.
Yeah, but that's 1800 and 1801. So, I mean, this is really something that, we've seen up and down throughout our history. Now, I think the thing is, since the Civil War, it's been fixed. So Roosevelt tried to expand it. It actually was a closer call. If things had broken right, he would have been able to expand the court. And basically, if he'd wanted to expand it by 4, he could have walked through, he could have done that very easily. So, what we're grappling with now is, though, for 150 years, we've been fixed in terms of the numbers. So it feels like it's outcome-oriented to change it.
All right. Here's a question. This actually relates to one of the cases we didn't talk about. I mentioned it briefly, the SEC case where the court, again, it's a Chevron, no longer deference to the SEC that says, look, you guys have your own courtrooms, and we don't think that's constitutionally appropriate under federal law. You have people who are being subject to your federal regulations deserve to be in a courtroom, not in your courtroom. So someone here wrote, given that the SEC wins about 100% of the cases it brings to its administrative courts, you've had experiences, I see. I'm one of those 100%, versus 60% brought in federal court. So that's an interesting, this person knows the statistics. You lose to the SEC 100% of the time in their courtroom. You lose 60% of the time in a federal courtroom. How can the SEC be judge, jury, and prosecutor be fair? So this person is making an anti-PhD don't take it personally, Bill, but it is about you. In the end, it's you. This person's basically saying, if it's so inside baseball with federal in a regulatory atmosphere, we have no chance, and give us a chance because these other people are unelected, yes, highly educated, but unelected.
Well, I really think they should take that argument to Congress where it belongs. Congress changed this law in the Dodd-Frank Act after the recession. It felt that the Justice Department and the SEC did not have sufficient personnel and resources to go after all of the civil fraud that was occurring.
So wait, so this is a post-2008?
So this is a post-08 reform. So they
wow.
gave the SEC the authority to impose civil penalties through in-house adjudication. A federal court gets to review all of those adjudications and the ultimate determination for due process compliance, or at least it did until this decision. I also think that part of what's going on here is the causation, the question might have the causation backward. If someone is guilty and they think they're going to lose, going to federal court is really not necessarily the best idea. Civil juries tend not to like civil fraudsters and can sometimes impose pretty major penalties. If they go in-house, it might be a safer bet, a safer gamble. Sure, they'll be found guilty, but they might have much less of a payout. And the reality is, I like juries. I don't mean to demean juries. And I'm sure if any of you in this room got on a jury involving civil fraud, you would fully grasp the intricacies of the law and render a fair decision. But I do not think that you are representative of the American public. And I think the problem is that many people on those juries don't fully grasp the issues the way that an administrative law judge who is trained in this, who has deep experience and knowledge, can apply consistency and principle to case after case and come up with a series of decisions that are fair and just.
Another strong argument in favor of the Chevron deference. All right, before we say goodnight, CLE code for those of you online in order to get your credit. TR, like in Thane Rosenbaum, TR 0321. TR 0321. So Law of the Land just finished its 9th year. Its purpose is to make the Supreme Court accessible, knowable, interesting, entertaining. I think that you did such an incredible job of opening its doors. This stuff is, for many people, opaque, even for lawyers. And I think people also, I think one of the things that I didn't get a chance to say, one of the themes that came up with Tiffany, Bill, and certainly with Mark, is the way they describe the politics within the court, right? What you were really describing was politics in the decisions, how they get written, who's saying it, why they're saying it. What's interesting is that the AP just did a poll, and it said, we know that Roberts is concerned about the declining public confidence in the judicial independence of the court. But 70% of the people believe that the court makes its decisions purely on ideological reasons. And it has nothing to do with the law. It's just purely ideological. That is a stunning number. And I thought that that's one of the things that I think you also opened up for us about how one can draw those conclusions given the way you described how the cases get selected, right? The strategies and how they lead them up and who they assign them to and what they say in their various opinions. Law of the Land concludes. Mark Stern, Jess Bravin, Tiffany Graham, Dean William Traynor. Thank you all for coming.